We turn now to crimes targeting group conduct. Under New York law, we said disorderly conduct was a violation. And I'm just going to point out number 6. There was several different versions of disorderly conduct, or ways that somebody can commit a disorderly conduct. And the 6th one is he congregates with other persons in a public place and refuses to comply with a lawful order of the police to disperse. But what if the person is engaged in a peaceful protest or assembly? The Constitution, under the First Amendment, protects us from government intrusion upon our right to peacefully assemble. However, group conduct can become criminal, especially if it enhances the potential for violence and injury. Such crimes include unlawful assembly, riot, and criminal gangs. Unlawful assembly and failure to disperse. Under New York law, this is our New York law, a person is guilty of unlawful assembly when he assembles with 4 or more other persons for the purpose of engaging or preparing to engage with them in a tumultuous, which is quite a broad word in and of itself, and violent conduct likely to cause public alarm, or when being present at an assembly which either has or develops such purpose, he remains there with intent to advance that purpose. So you could be someone who is already there engaged, 4 or more people, or you become a part of it when it arises to that level. In New York, it is a Class B misdemeanor, which is the lowest level misdemeanor. It's 1 step up from the violation, 1 step below our Class A. Unlawful assembly can be the predicate offense to riot, which we're going to discuss in a moment. The criminal elements, assembling of a group. That's the act, when you assemble as a group. The intent has to be intentional or purposefully. That a breach of the peace occurs, which can also be either an unlawful part of the unlawful act or the cause of that assembling. And attendant circumstances depends on the state definition, but we're using New York, and that is the people in the group. If it's 3, then you don't have it. It's got to be 4 or more. That's what New York deems as a group of people, 4 or more. 3 is not a group. 2 is not a group. Under the common law, that was 3 or more, when 3 or more individuals assembled for an illegal purpose. Then you had the offense of unlawful assembly. That was completed the offense. If you had 3 or more people and you assembled for an illegal purpose, it was complete. You didn't need the commission of something else or an additional overt act. And most of the modern state statutes, including the New York one, requires both an assembly and the commission of one of the acts prescribed by statutes, even if the purpose of the assembly is not completed. Generally, an unlawful assembly is a misdemeanor, like I said, in most states, and under the common law it was. The basis of the offense of unlawful assembly is the basis is the intent with which the individuals assemble. The members of the assembled group must have in mind a fixed purpose to perform an illegal act. The time when the intent is formed is immaterial, and it does not matter whether the purpose of the group is lawful or unlawful if they intend to carry out that purpose in a way that is likely to involve a breach of the peace or precipitate a breach of the peace. An assembly of individuals to carry on their ordinary business is not unlawful. Conversely, when 3 or more persons under the common law assemble and act jointly in committing a criminal offense, such as assault and the battery, the assembly is unlawful. All those who participate in unlawful assemblies get the criminal responsibility. They incur the criminal responsibility for the acts of their associates performed in furtherance of their common objective. The mere presence of an individual in an unlawful assembly is enough to charge that person with participation in the illegal gathering. Political gatherings and demonstrations raise the most troublesome issues involving unlawful assembly. The line between protecting freedom of assembly and protecting the peace and tranquility of the community is quite difficult for courts to draw. And as we have seen across the country in the last several months, how these types of charges work and actually play out. We've seen it on TV and feeds. The court holdings on unlawful assembly. Although the public may fear a large, noisy assembly, particularly an assembly that espouses an unpopular idea, such an apprehension does not warrant restraints on the right to assemble unless the apprehension is justified and reasonable and the assembly poses a threat of violence. This is what the majority of courts hold with this definition in mind. Examples of a genuine unlawful assembly would include situations such as angry at a televised police beating or assault. A group of protesters take to the streets with lighters and torches, and they plan to destroy cars and buildings. Another example is angry at a jury verdict. A group of protesters march to the courthouse with bats and clubs, shouting, "Let's get these MFs, motherfuckers," so to speak. Whereas something that would not amount to an unlawful assembly is students angry over tuition hikes, and they go out and they march in the city plaza carrying signs and chanting. That is a peaceful protest. Of course, a lawful assembly can become an unlawful one if what starts out as a peaceful protest later turns violent. Courts have explained that it is immaterial at what time the intent to do the lawful act in an unlawful manner is formed, whether prior to or during the assembly. Mere presence in the group can constitute a crime. Simply remaining in a group that has become violent or otherwise unlawful is sufficient to constitute an unlawful assembly. And as the courts further have said, the statutory denunciation pertains to the assembly at large. Not every member of the assembly must individually commit unlawful acts to render the assembly unlawful. If a person is a participant in a lawful assembly which becomes unlawful, he has an immediate duty upon learning of the unlawful conduct to disassociate himself from the group. Of course, there's situations that arise where some factions in the protest become violent and unruly, while others remain peaceful. Courts have said that a jury must ultimately determine which group a defendant was in. The extent of the group and the membership therein are merely questions for a jury to decide. Defenses to an unlawful assembly charge. Arrests for unlawful assembly occur obviously in chaotic situations where it's hard for law enforcement to decide exactly who did what. This can make the charges difficult for the prosecution to prove in court. But some typical defenses that have proved successful are things like the group was not perpetrating violence, nor was there a clear threat of imminent violence. Even if some in the assembly had become violent, this defendant was part of a peaceful faction that was acting lawfully. Or another one is the defendant was not given time and an opportunity to leave the group before getting arrested. Those are common defenses. They don't work every time, but they could be successful. Let's step it up to riot. Riot can be the result of an unlawful assembly that escalates or can occur spontaneously without planning or some predicate activity. We did discuss incitement to riot under Chapter 3 in Constitutional Protections. Inciting a riot is not protected speech. Under New York, a person can be arrested for inciting a riot when he urges 10 or more persons to engage in tumultuous and violent conduct of a kind likely to create public harm, public alarm. Notice it says 10 or more, so if there's 9, you're not inciting a riot. Anything less than 10 wouldn't count. We'll have to do a head count. Actually, I think there would have to be 11 of them. If you have a person and then you're urging 10 or more persons, so that would be 11 altogether in something like that. But it steps up from there. So we have the person who actually, they don't have to be involved in the riot. They just have to be the one that incited the riot. And now we have a person who's actually involved in a riot. So a person is guilty of a riot in the second degree in New York State when simultaneously with 4 or more other persons, he engages in tumultuous and violent conduct and thereby intentionally and recklessly causes or creates a grave risk of causing public alarm. So if it's 3 or less, you don't have it. But one person and four or more others constitutes a Class A misdemeanor for rioting. And then it steps up from there. We should say this is going to be between 4 and 9 people because our felony elevated riot involves 10 or more. So we cross the line at that point. And that's what, it's the same charge. You just have more people and then it elevates to a felony. Criminal act, a group commission of tumultuous and violent conduct. That's the act. It can be intentional or purposely if you're in a different state. Or it could be recklessly. So in New York, intentionally or reckless. And you have to have a causes or creates a grave risk of causing public alarm that causes injury to another who didn't participate. If one of the people in the group got hurt, then oh well. And the harm. You have to actually have somebody getting hurt who's not a participant. So this is a specific intent crime. Attendant circumstances, numbers in the group. If you want the felony, it's got to be 10 or more. 10 or more. Before I move on to criminal gangs, I don't think I have to give you an example for riots. There is one in the book. It does fit the definitions of a riot, but I believe if you have looked at your social media feed or saw the news every day, it's still on the news. You can take a few minutes to Google what has been occurring in our country over the last several months, that you can get an idea of what constitutes unlawful assembly, peaceful assembly, the difference between the two, what gives rise to a riot. So with that, we're going to switch to criminal gangs. Many states and the federal government have laws that address criminal gangs, which continues to be an ongoing dilemma in many areas of the country. Generally, gang membership involves assembly, which if it's peacefully done, it's protected under the Constitution. So how do states and the federal government criminalize gangs? Well, their statutes must be specifically defined regarding what constitutes a criminal gang and a criminal gang member in order for there to be some level of an arrest. The federal government defines a criminal street gang as an ongoing group, club, organization, or association of 5 or more that has that has as one of its primary purposes the commission of specific criminal offenses or activities that affect interstate or foreign commerce, so human or drug trafficking. So the federal government can't charge someone for a crime unless the crime constitutes something that is being done country to country or from state to state. It has to be interstate or transnational for the federal government to get involved. They don't regulate like the gangs in LA unless they're operating between LA and Mexico. Then they would. But if it's strictly within the state of California, that's going to be California. If it's specific to New York, it's going to be the gangs are conduct is specific to New York. It's going to be the state that will have to deal with it. So the feds defined a gang member as someone who participates in a criminal street gang with the intent or knowledge that its members engage in a continuing series of specific crimes, or an individual intends to promote or further the felonious activities of the criminal street gang. Transnational criminal gangs pose an immediate, clear, and present danger to the security of the homeland and its communities. And gangs can be involved in, a whole list of criminal activity, from murder to extortion to narcotics and weapons trafficking, as well as human smuggling and trafficking and prostitution, and a whole other crimes with a nexus to the border. And it is the U.S. Immigration and Customs Enforcement, ICE for short, and Homeland Security Investigations. These agencies are tasked with the investigations of criminal gangs, not necessarily the FBI. Sometimes our FBI gets involved, but as of currently, it is ICE and Homeland Security that are primarily involved in gang crimes at the federal level. Large cities like LA have gang task force that are made up of various law enforcement agencies, and generally the FBI would sit on something like that. Same with New York. New York State does have laws that regulate gang activity, but they don't say it, just like the feds do. What it uses is criminal enterprise. That encompasses a whole lot of, it could encompass, mafia and the mob, which is a type of gang. So New York uses criminal enterprise, means a group of persons sharing a common purpose of engaging in criminal conduct associated in an ascertainable structure distinct from a pattern of criminal activity and with a continuity of existence, structure, and criminal purpose beyond the scope of individual criminal incidences. And from there, that's a definition, but from there, we have a crime of enterprise corruption. And I won't read it to you as I have been. I'll let you go through that. But this is how New York deals with gang activity on a specific level to charge with such conduct that they're engaging in. Certainly members of gangs can be charged specifically with murder and with extortion and with assault, with the actual specific crime that anyone can be charged with. But these are specifically tied to the enterprise, quote unquote, in and of itself. The other thing, how gangs are treated relative to criminal statutes, not only in New York, but in all, the feds do it as well, in all of the states. What they do is, I do have it. Yes, I do have it here. They have gang participation as being criminalized by the sentence that one can receive, and the sentence enhancement. Meaning, I'm going to give you this example for New York State. You can look up the statute, and when we did assaults, you may have seen this in there, or maybe you actually wrote about this one, is gang assault. If you look under the assault statutes, all different ones. There is one that says gang assault. And what happens in the statute says somebody with the aid of two or more persons intend to cause physical or serious physical injury upon another. And depending on whether it's just a physical injury, I broke your nose, or if it's a serious injury, I put you in a coma in the hospital, will depend on the grade level. So here's how it works. And like I said, all states have this, and the feds do this as a penalty enhancement too. When you're dealing with gangs. And it's not only with gangs, they also have enhanced sentences, as we talked about earlier with hate crimes. If it's an assault, but it was driven by hate, and the prosecution shows that, you can elevate the sentence. Weapons also. But let's use this for the gang assault as an example. So we have Joe and Mike are at a bar watching the hockey playoffs, and they have a few drinks. Mike starts taunting Joe over the fact that his team is losing. Joe has had a few too many drinks, and he's sensitive. He takes offense to Mike's statements, and an argument ensues, and Joe punches Mike in the face, sending him to the ground. But on the way down to the ground, Mike hits his head on the bar, and he's taken to the hospital, and he has suffered a severe head injury. Joe is charged with assault in the second degree under state of New York, and it's a felony because he caused a serious physical injury requiring immediate medical attention. And if Joe is found guilty, the judge can sentence him to it's a defined sentence, definite sentence, so he can get anywhere for a minimum of 2 years in prison and up to 7 years in prison. So that's the range the judge can sentence Joe to for that charge. Now let's say we have the same example, except Joe can't take any more of Mike's taunting and storms outside to the parking lot, and he's stewing, and he's drunk. He's been drinking. And Larry and Bob show up. Those are Joe's friends. They pull up and they ask Joe what's going on, and he says he wants to kick Mike's ass and tells him what's been going on. And he asks Larry and Bob to join him in the bar to confront Mike. So Bob grabs the baseball bat from the back seat of his car, and the three head in to the bar. And as they walk up to the bar, Larry shoves Mike, who falls into the bar, and Joe sucker punches Mike in the face. And Mike, as he's going down, hits his head on the bar, and he's taken to the hospital. He suffered a severe head injury, and now he has this serious physical injury. And now we have gang assaults. We have 3 folks who are now arrested, even though Bob didn't use his bat. Bob was standing in the back. We have gang assault, and all 3 of them can be charged with gang assault, and they will face a hefty penalty of between 5 and 9 years in prison for the same injury that Mike got, except now there's 3 of them. And even if Larry did not shove Mike, let's say Joe's out walking in front, and the other 2 got his side, got his back. They're on either side of him, and they walk up to Mike, and Joe just sucker punches Mike, and he falls. The other 2 don't do anything. Still gang assault. So that's how states and the feds treat the gangs, even though they do have a right to peacefully assemble. At some point, if their activity changes to be in a criminal manner, there are ways to treat that. And as you can see, and the one primarily used is the enhanced sentence provision. Because, like I said, any member of a gang can be arrested for any number of crimes that they're involved in. But what the police cannot do, if there's, a group of 5, let's say 5 young men hanging out on a street corner, you think the police can't drive up and say, "Oh, you're a gang, I'm arresting you all." That can't happen because they're peacefully assembling on the corner. All right, the next way, another way that's been used, it's not particularly popular. California has used it, but I have some links, before I forget, I have some links on Moodle to videos regarding gang injunctions. Number of problems with those. The couple videos that are posted, one is from a prosecutor's point of view. The other one is from a individual who is subject to a gang injunction and their points of view. It's interesting how it's used and how sweeping it can be used to people who aren't even involved in gangs. But I'm digressing. So take a look at those videos after you listen to this discussion so you know what they are. A gang injunction. A gang injunction is a restraining order against a group. It is a civil suit, is what it is, that seeks a court order declaring the gang's public behavior as a nuisance and asking for special rules or orders directed toward their activity. Injunctions can address the neighborhood's gang problem before it even reaches the level of a felony crime activity. This is the definition out of California because I liked it better than the one that they use in the book. The order itself prohibits gang members from associating with other gang members or entering certain areas for gang activity. It is on a state agency, which could be a police department, or any private individual in a gang-infested area can make this request to the court to issue such an order, but they don't just get it. You don't just get it willy-nilly. They actually have to, the one who's actually doing the asking for the injunction has to provide proof that the gang is disturbing the enjoyment of life and property for those living in the community. They actually call this a nuisance action. That's what it's actually called. It's a civil tort claim. Little background. The provisions of the order can include prohibiting association with other members, wearing gang colors, flashing gang hand signs, or loitering in areas where gang activity is known to take place. And the order actually lists specific names of people who they believe is part of the gangs. And once the court issues such an order, a violation or doing any one of the directives that the court indicates they can't do, a violation of the order constitutes a contempt of court, which can result in incarceration and or fines. And there's lots of problems with these, including sweeping up people who have had no involvement with criminal activity, including young teens whose older sibling or parent or some other relative is associated with a gang. And by their association, they get included in these, and they're afraid to go out and be in public or do anything. So the videos are short, and the videos, focus on these problems. One's from the government's point of view, and then another one is from an individual's point of view. So take a look at those with regards to the gang injunctions and the problems that arise.